So, for centuries, the whole concept of legal privilege was really built around, well, the physical reality of a locked door.
Right. The classic lawyer's office.
Exactly. You step into your lawyer's office, that heavy wooden door clicks shut, and whatever is said inside that room basically exists in a vault. It is a binary, architectural boundary. Inside the room, your communications are protected. Outside, they are not.
Yeah. It's a very straightforward physical way to understand the law.
It is. But we have an analytical legal memo today that asks a huge question. What happens when you take highly sensitive legal strategy, walk out of that locked room, and voluntarily feed it into a generative machine that lives on a third-party cloud server?
Which is exactly what we saw in the Southern District of New York.
Right. The February 2026 ruling by Judge Jed S. Rakoff in U.S. v. Heppner, the court stripped attorney-client privilege and work product protection from 31 documents that a defendant generated using Anthropic's AI tool, Claude.
It's a massive shift.
It really is. So the central question of our debate is this: does utilizing a public AI tool to process legally sensitive information inherently destroy confidentiality? Because my position is absolutely yes. I support the court's strict application of traditional privilege principles here. By voluntarily feeding sensitive info into a third-party platform, the user completely obliterates any reasonable expectation of privacy.
Well, and the inverse of that question is just as critical, right? Did the court fundamentally misunderstand the technical reality of modern AI privacy policies? Because my stance is that they did. This ruling sets a dangerously broad precedent. It basically penalizes a user based on a flawed, overly rigid interpretation of how standard digital tools function during legal prep.
Okay, let's lay out exactly what happened, because the facts here really dictate the boundaries of the privilege. So, in November 2025, Bradley Heppner is facing an impending federal fraud indictment.
High-stress situation.
Very high stress. And without consulting his attorney, acting entirely on his own volition, he logs into Claude. He inputs sensitive information, stuff he had actually gathered from his counsel, and asks the AI to help him outline defense strategies and anticipate charges.
Right. He's trying to organize his thoughts.
Sure, but Claude is a public third-party platform. It explicitly disclaims the ability to provide legal advice. And, crucially, by accepting Anthropic's terms of service, which allow data to be shared with regulatory authorities, Heppner forfeited any claim to confidentiality. The traditional legal doctrine worked exactly as intended here to pierce an invalid shield.
See, the outcome for Heppner specifically might seem logically sound if you only look at the surface-level timeline. He acted alone, and yes, that was his fatal error.
A very big error.
Definitely. But the court's underlying reasoning regarding confidentiality is deeply flawed. Judge Rakoff's ruling relies on a rigid, frankly technically inaccurate reading of standard technology privacy policies.
How so? The policy says what it says.
While the source materials analysis points out that Anthropic's privacy policy actually states they will not use inputs or outputs to train their models unless the user explicitly opts in. The court kind of misrepresented how data is actually handled, creating a framework where just agreeing to standard software compliance terms somehow destroys legal privilege.
But we have to look at why this privilege exists in the first place, right? The attorney-client privilege is not just some mechanism to hide inconvenient documents from the prosecution.
No, of course not.
It is a narrow exception to the rule that the public has a right to every man's evidence. Because it is an exception, it requires absolute, airtight confidentiality, and it requires a trusting relationship with a licensed professional who owes you a fiduciary duty.
I agree with the premise, but
Claude is not an attorney, like I said. The platform explicitly disclaims the ability to provide legal advice. More importantly, when Heppner created his account, he accepted terms that allow the platform to retain his inputs and disclose them to government authorities if required by law.
yeah, you are hitting on the exact language the government used to destroy his claim of confidentiality. But we really need to examine what that privacy policy dictates mechanically.
Okay, let's examine it.
The court leaned heavily on the idea that public AI tools inherently collect and analyze data in the normal course of business. They essentially treated it like an open broadcast system. But the training data loop is closed.
The training data loop might be closed, sure, but the retention loop is not. the platform retains the prompt history on their servers.
Which is standard for cloud computing.
But if a query triggers an automated flag for illegal activity, like, say, structuring a complex financial fraud, it can be routed to a human trust and safety team for review. If the human reviewer at a tech company in San Francisco has the technical capability to read your defense strategy, how can you claim that information is locked in a vault?
Because that exact same capability exists in almost every piece of enterprise software used by attorneys today. I mean, this is where the court's technical reasoning just falls apart.
Wait, you're comparing an AI model to regular enterprise software?
Absolutely. Think about it. If a major law firm drafts a sensitive appellate brief using Microsoft Word 365, that document lives on a Microsoft Azure cloud server.
Right, but
And Microsoft's privacy policy contains a nearly identical clause stating they will comply with lawful subpoenas, regulatory requests, and can review data to prevent abuse. That does not mean the lawyer has waived privilege by typing the brief on a cloud-connected machine.
that's entirely different.
How? Retaining data securely on a server is simply how the modern internet functions.
There is a monumental difference in the architecture of a passive word processor and a generative AI model. It comes down to the active nature of the technology. Let's look at the expectation of privacy through a behavioral lens.
Okay, behavioral lens. Go ahead.
What Heppner did was not the equivalent of saving a secure document on Azure. It was the equivalent of taking his legal strategy, sitting down in a crowded coffee shop, and discussing it with a highly intelligent stranger who actively takes notes, synthesizes the information, and talks back to him.
Oh, the coffee shop analogy.
It works. The AI is processing the semantic meaning of the text to generate a novel response. It is an active third-party participant.
I'm sorry, but I just don't buy that. Let me tell you why. That coffee shop analogy is exactly what the government successfully argued, but it fundamentally mischaracterizes generative inference.
It's an active system, though. It's not just a blank page.
But using an AI tool is not shouting your strategy across a barista counter. It is much more akin to writing in a secure digital diary that happens to have computational capabilities. The court completely conflated consumer AI web interfaces with public broadcasting.
But it parses the text. It understands it.
Yes, it parses the semantic meaning of the text to predict the next token in a sequence and generate a response. But it does this within an isolated, ephemeral compute instance. The fact that the machine understands the text well enough to summarize it does not transform it into a third-party listener in the human sense.
I think that's a semantic distinction.
It's a technical distinction. To suggest that an algorithmic process breaks the circle of trust is to anthropomorphize the software.
Well, you cannot just wave away the terms of service because the so-called listener is silicon rather than carbon. The platform retains the legal right to hand that data over. But let's follow your logic for a second.
All right.
Let's accept that Claude is just a highly advanced digital diary. We run headfirst into the second massive hurdle for Heppner, the purpose of the communication and the standard for legal advice.
Right, the purpose test.
Exactly. The privilege doctrine clearly states the communication must be for the explicit purpose of obtaining or providing legal advice from a lawyer. During the investigation, the government literally asked Claude if it could provide legal counsel.
And it gave the standard disclaimer.
It outputted, "I'm not a lawyer and can't provide formal legal advice." If the tool explicitly tells the user, "I cannot act as a lawyer," the user cannot logically or legally claim the interaction was for the purpose of obtaining legal advice.
I will concede that is probably the court's strongest point. But we have to look at the mechanism of how human beings process complex information, especially when facing the overwhelming stress of a federal indictment.
Stress doesn't rewrite the rules of privilege, though.
No, but Heppner was not asking Claude to represent him in court. He was using the software's computational ability to synthesize a massive, convoluted set of financial facts into a structured timeline.
Right, on his own.
Yes, but why? In order to communicate more effectively with his actual human counsel. The defense argued that organizing one's thoughts is a necessary prerequisite to seeking legal advice.
But doing research so you can eventually talk to your lawyer does not retroactively cloak that research in privilege.
Why not? If it's part of the preparation process.
Because of a third-party involvement. Think of it like this. If I go to the public library, pull a law textbook, and take notes in the margins of my own notebook to understand my case better before I call my attorney, those notes aren't privileged.
They're just your private thoughts.
Exactly. They only become privileged when I communicate them to the lawyer. Judge Rakoff noted that because Heppner first shared these complex factual scenarios with the AI, a third party, he broke the chain of confidentiality before the lawyer ever entered the picture.
See, your library notebook analogy proves exactly why this ruling is so problematic.
How?
It perfectly illustrates the timeline issue.
Because if you take notes on a yellow legal pad in the library, those notes are your private thoughts. If you then hand those notes to your lawyer to facilitate legal advice, the communication of those notes is protected.
But the AI isn't a legal pad.
The court here drew an arbitrary, invisible line between organizing your thoughts on a physical yellow legal pad, organizing them on Microsoft's Word, and organizing them via a generative AI prompt box.
It is not an arbitrary line.
The underlying human action is identical. You're synthesizing complex information into a digestible format to prepare for a legal consultation. By declaring that the AI prompt box is an inherently public forum, the court effectively outlawed digital preparation.
Again, the line is drawn at the boundary of the fiduciary relationship. You keep circling back to the idea that the AI is just a tool, like a pen or a word processor.
Because mechanically, it is a tool.
But a pen does not generate strategic legal theories. A pen does not suggest alternative defenses. The moment Heppner asked the AI to analyze the facts and output a strategy, he engaged in a two-way communication with a non-fiduciary.
I see what you're saying, but
He stepped outside the protective umbrella of the attorney-client relationship. You simply cannot separate the generative nature of the tool from the transaction itself.
which forces us to look beyond just the attorney-client privilege and examine the work product doctrine. Because even if we concede that the strict fiduciary bond wasn't present, we still have to grapple with why these documents failed to qualify as protected legal strategy.
Well, the work product doctrine is entirely distinct from attorney-client privilege. It originates from the landmark case Hickman v. Taylor.
Right, anticipating litigation.
Exactly. Its core purpose is to protect the mental impressions, theories, and strategies of the attorney in anticipation of litigation. It exists so that lawyers can prepare for trial without fear that the opposing counsel will just subpoena their brainstorming sessions.
It protects the adversarial system.
Yes, but Heppner wasn't an attorney, and he wasn't acting at the direction of one. He ran these queries after getting a grand jury subpoena. He realized he was a target, panicked, and went rogue on a consumer AI tool.
Unilaterally.
Unilaterally, you cannot generate a bunch of independent, unprompted research, hand it to your lawyer weeks later, and suddenly claim, oh, this is protected legal strategy.
I will concede that the timeline doomed his claim. Acting without his counsel's explicit direction was absolutely his fatal error.
Right.
But we have to examine the incredible caveat that Judge Rakoff included in his opinion, because it exposes a deep contradiction in the court's understanding of the technology.
You're talking about the agency exception?
Yes, the judge explicitly noted that if the situation had been slightly different, if the legal counsel had directed Heppner to use the AI tool to organize his thoughts, Claude might arguably be said to have functioned as a lawyer's agent.
Right, which refers to the exception established in United States v. Covell.
Exactly. The Covell exception is a pillar of modern legal practice. Back in 1961, the courts recognized that lawyers are not financial experts.
They definitely aren't.
Right? So if a client brings a mountain of complex financial records to a lawyer, the lawyer often needs an accountant to translate that financial gibberish into a structured format the lawyer can actually use.
And the communications with that accountant are protected because the accountant is acting as a necessary translator for the legal strategy.
Exactly. And Judge Rakoff suggested that an AI could theoretically serve that exact same translator function.
Which is a perfectly logical extension of the doctrine. If the AI is performing the mechanical sorting and translation of data at the behest of the attorney, it falls under the umbrella of the attorney's strategic preparation.
But look at the bizarre technical paradox this creates. Mechanically, the data inputs are exactly the same.
Well, legally, they are categorized differently.
But physically, computationally, the LLM's generative inference process is exactly the same. Anthropic's server architecture, the privacy policy, the potential for trust and safety review, none of the technical reality changes.
That's true.
Yet the exact same prompts and outputs are deemed either highly confidential legal strategy or completely unprotected discoverable data, entirely based on whether a lawyer first picked up the phone and said, "Go log into Claude."
Because the lawyer provides the formal boundary.
But the court's earlier argument that the software's privacy policy fundamentally destroys confidentiality is completely contradictory here. A privacy policy cannot simultaneously be so porous that it destroys privilege for a layman, but suddenly secure enough to protect work product just because a lawyer authorized the login?
It is not a contradiction. It is the necessary functioning of formal legal boundaries. The work product doctrine requires the guiding hand of legal strategy.
Even if the server risks are identical?
Yes, because when a lawyer directs a client to use a tool, the lawyer has made a strategic calculation. A competent lawyer will have vetted the tool, assessed the data retention risks, perhaps ensured they are using an enterprise API with zero data retention policies rather than a consumer web wrapper.
That is a big assumption about tech-competent lawyers. But fair enough.
They bring the tool within the formal scope of their representation. When the client acts unilaterally on a free consumer app, there is no strategic calculation by a fiduciary. The law requires these formal boundaries.
I just think it's overly formalistic.
If it wasn't formalistic, any litigant could claim that every Google search they conducted, every digital note they typed, and every AI query they ran after getting a subpoena was anticipating litigation and therefore off-limits to discovery.
Well,
You would have absolutely no evidence left in modern fraud cases.
you are drawing a hard line on formal boundaries, but that ignores the practical reality of how people interact with the justice system today.
How do you mean?
Think about pro se litigants, people representing themselves because they cannot afford an attorney. They are increasingly relying on generative AI tools to navigate an incredibly complex, opaque, and intimidating legal system.
That's a valid concern, certainly.
If the baseline judicial assumption is that interacting with these tools inherently generates discoverable, non-privileged data, we are creating a massive trap for the unwary.
But the standard has to be maintained.
But look at the inequity. A corporate defendant with high-priced counsel will get the formal, documented instruction to use a secure, enterprise-licensed AI, protecting all their strategic data under the Koval exception. An under-resourced individual trying to organize their thoughts on a consumer AI will have their entire strategic thought process systematically handed over to the prosecution.
The solution to that inequity isn't to dismantle centuries-old requirements of privilege and magically extend protections to public platforms.
Then what is the solution?
The solution is digital literacy and technological adaptation. The architecture of the AI tool absolutely matters, and the market is already shifting to accommodate this. If confidentiality is the goal, users cannot rely on consumer-facing web wrappers.
So they need private networks.
Exactly. They need to utilize tools that operate entirely within a private network environment. Take edge AI computing, for example. We are seeing a rapid rise in open-source large language models running locally on a user's own silicon on their device's neural processing unit.
Okay, yes, running a model locally changes the paradigm completely.
Completely, because with Edge AI, the data never leaves the laptop. No packets are sent over the internet. There is no cloud server, no Anthropic terms of service, and no third-party tech company retaining the prompts.
Right, it's totally contained.
If Heppner had downloaded a local model and run it entirely on his own hard drive, the government wouldn't have been able to leverage the third-party disclosure argument because the third party literally would not exist.
That is true.
The responsibility lies with the user to understand the mechanics of the tools they are utilizing. You cannot demand the absolute protections of a locked digital vault while choosing to conduct your business on a server you do not own or control.
Digital literacy is vital, I agree. But the court also bears a responsibility to accurately understand the technology it is regulating.
They understood the terms of service perfectly well.
But the court shouldn't be relying on the government's broad, technically imprecise characterizations of how AI operates to make sweeping legal determinations.
You think the ruling will cause that much collateral damage?
I do. The fact that the court leans so heavily on the idea that public AI is an active third-party listener, conflating computational summarization with human disclosure, shows a dangerous gap in judicial understanding.
It is a conservative approach to new tech, for sure.
But an unintended consequence of the Heppner ruling will be an explosion of aggressive discovery requests. Opposing counsel will now routinely demand access to a litigant's entire generative AI history, just fishing for early, unguided strategic thoughts.
Well, they ask for email drafts already.
But this is different. We are entering an era of litigation where the rough draft of your own defense is now a weapon for the prosecution.
Well, to summarize where I stand on this, the facts of this case and the resulting analysis make it abundantly clear that we are navigating highly fact-specific territory.
Very fact-specific.
Moving forward, the ad hoc use of consumer AI for legal preparation is a massive liability. If a party wants to use generative AI to process legally sensitive information, the procedural rigor just must be absolute.
Enterprise licenses, edge compute.
Yes, they must utilize enterprise license pools with verified, closed data loops or edge compute models. And crucially, there must be explicit, documented directives from legal counsel.
A clear paper trail.
Precisely. Non-lawyers will need to separately document that they are querying an AI tool specifically at their counsel's direction to successfully invoke the agency exception. The Heppner ruling doesn't punish modern technology. It reinforces essential boundaries that keep the adversarial system functioning. Privilege requires a fiduciary duty and absolute confidentiality.
I hear you, and I agree that the days of casual digital legal preparation are definitively over.
Completely over.
If you are involved in litigation, or even anticipating it, every interaction with an AI must be treated with the same exactness as hiring a forensic accountant. You need the paper trail establishing the lawyer's direction before you type a single prompt.
Right.
But I maintain that while Heppner's specific unilateral actions doomed his own work product claim, the court's clumsy characterization of cloud privacy policies creates a very precarious landscape.
It's definitely a warning shot.
It threatens to penalize standard digital behavior and misrepresents how data privacy actually functions in the modern era. But as you pointed out, the technical nuances, like edge AI, will probably be where this fight goes next.
The tension between rapidly advancing generative inference and established legal doctrines is only going to intensify. It forces us all to deeply consider how the everyday tools we rely on to synthesize information might fundamentally alter our legal protections.
The evolution of artificial intelligence in the courtroom is really only just beginning. The technical lines we draw today, whether distinguishing between an API endpoint and a web wrapper, or between a cloud server and local silicon, will absolutely dictate the future of privacy in our justice system.
When we began this discussion, we talked about that heavy wooden door clicking shut in the lawyer's office. Today, the vault isn't just a room anymore.
No, it's a network.
Exactly. It is a complex web of cloud servers, localized neural processors, and end-user agreements. And as the Heppner case clearly shows us, the lock on the digital vault is changing, and we are all going to have to learn the new combination.